All right, ladies and gentlemen, we're going to commence the next panel. It's my privilege to introduce to you the gutsiest lawyer in Canada. I told John Rosen that the Bernardo case is the case from hell, and by the time it's all over, I think the major participants will all need therapy, and so it's a good thing that we have John here in a saner moment. I've had a number of trials with John over the years. He is an extremely hard worker and an excellent advocate. And I'll turn the panel over to John.
Thank you, Earl. Your envelope is outside. Because we're running behind time and we have a lot to say, let me quickly introduce the panel to you. To my immediate left is Dr. Cecilia Hageman from the Center for Forensic Sciences. To my right is Kathy Cooper from the 720 Bay, and she's the token crown, and my associate Timothy Breen on the far right. And we're here to talk to you about forensic evidence, particularly body fluids and that sort of thing. We're not the DNA panel, although we're going to touch on some of that, but we're here to talk to you about the nuts and bolts of the average forensic case and what happens, how you get the reports, what to do with it, and some other problems. And if I could start with Dr. Hageman, who's going to tell you a little bit about the center, about what they do, how they get their stuff, and how they generate the evidence that you ultimately have to face.
Well, good morning. For those of you who haven't dealt with us much, I'd like to talk to you just a bit about the nuts and bolts, as John has said. We're the Government of Ontario's forensic lab. Between us on 25 Grosvenor and our Northern Regional Lab in Sault Ste. Marie, we do the forensics examinations for all of Ontario. The RCMP has maintained a lab in Eastern Ontario, but they are gradually diminishing all operations, so that eventually I think we will be the only game in town. We are divided in 6 sections based on scientific discipline. I've listed them on page C26, C27, and I think they're mostly self-explanatory. I'm a member of the biology section, where we examine items for blood, body fluids, hairs, fibers, botanical materials. As a serologist, I stick to blood and other body fluids. The hairs and fibers are done by our trace unit, and we won't be discussing that today. Who submits items to us? It's usually police officers. They're the people who we consider our main clients. Police officers of all stripes. In the larger cases, we deal with identification officers, and they are specially trained to photograph scenes and, particular to us, to properly collect evidence at the scene, to properly maintain them, the continuity once they get to us. Later, of course, we deal with the detectives on the scene and so forth. Police are not our only clients, and maybe of interest to you that we do have lawyers that submit items to us. And for those of you who have not dealt with us, please turn to page C28. We have a number of policies regarding submission of items. These are the 3 big ones, and I hope that everyone after they come out of this really understands this. 1, we don't charge for our scientific examinations in criminal matters. Hopefully that will not change. I haven't heard anything to that effect. Secondly, if you're a defense counsel, you want us to look at an item, we'll do so, but only if you give us a written acknowledgement that you will disclose our reports to the Crown. If we don't have a written acknowledgement, we do not do the work, and you'll have to find a private lab to do the work, which is a bit difficult in Ontario when we realize that. Once we've issued a report, we've done all our work, we are open to both sides for discussion, and we encourage this, especially if we're going to some kind of jury trial. If we can get rid of an issue, if we can explain something to you beforehand, I think everybody benefits. If the reports that we submit to you are not enough, you have questions, if you want to come and look at the original work notes, please give us a call and we'll try to accommodate you. If you just show up, I think we're just going to shove you away, but if you talk to us beforehand, we'll set up a meeting, take a look at our work notes, and we'll discuss everything to do with that case. Now, how do you submit items? Get a copy of our handbook. I don't have a copy with me today. It's called Lab Aids for the Investigator. I've given you a cite to that on page C27. It tells you what we do, how you wrap items, how you submit items to us. The problem with the book is, before I think it's such a great thing, it's a 1984 edition. We don't include in that book yet descriptions of our new DNA techniques. That is coming, and as soon as we have a new edition out, I'm pretty sure you'll know about it. But it's a handy little book to have, just to tell you exactly, well, what do I do? I have a blood sample, how do I get it to CFS? It will tell you in that book. Submitting to us, you do not submit directly to scientists. That was the old system, I believe. Now, you do not deal with us on a one-to-one basis in the beginning. You go to our second floor, you deal with our center's receiving office. We have scientists and technicians there whose only job it is to collect items, to make sure that everything that you submit is properly submitted and properly documented. An example of that document is on page C33. That's a case submission form. All items must be accompanied by one of these case submissions. And if these filled out case submissions are fonts of information. You will see, for example, in the middle, a case history. This is the officer's version of what happened in a case, and is what we go by in order to determine what scientific examinations we do. Look for your version. If your version is different, well, then maybe that's a point in issue. Bottom of that list. It's a list of all items submitted to us, all the items that we don't accept for submission, sometimes with reason, sometimes not. And on the top, of course, it's just dealing with the numbers, with the people who are involved in submitting, how items were submitted. You'll find out whether or not they came in directly, whether they came in by perolator, whether they came in by the locker system. This may be important in your continuity. We start logging continuity when we get the items, not before. That is the responsibility of the police officers. So all of that will be on the case submission form. And for you to submit items, you have to get a form and fill it out yourself. Now I'll talk a little bit about the biology section for a minute. The types of cases we do: is there a bodily fluid? Has a bodily fluid come from one person to another? What kind of fluid is it? Is it human? Isn't it human? How could that fluid have gotten there? And our basic reason for existing is grouping. Who could or who couldn't have been the source of a particular bodily fluid? And many of our resources are into that issue, into that area. For those of you who have seen our reports before, you've seen what we call conventional grouping systems. Those are what we call the old grouping systems, ABO, PGM, things like that. These are genetically based grouping systems, but they are not DNA systems. We are moving now toward all DNA grouping systems, but it's going to be a slow move. On page C13, you'll have a list of all the conventional grouping systems that are still in use. That list is getting smaller and smaller, and our list of DNA-based grouping systems are getting larger and larger. And why are we making the move? Two reasons. One, if we make a match, the potential number of people who are a potential donor is greatly reduced for DNA grouping systems as opposed to conventional grouping systems. And secondarily, we can do so much more with different bodily fluids. The old conventional systems we did basically on blood, sometimes on hair roots, but mostly on blood. With RFLP, that's the DNA-based system, and PCR, that's polymerase chain reaction, that's our new DNA system. We can look at, I'll give you an example, blood, saliva, semen, nasal secretions. For example, officers now know that if they have a blubbering suspect in the interrogation room, they give them a Kleenex, and that Kleenex comes to us. And it's a pretty good control group, so just so you know. Hair root sheaths work quite well. If you pluck a hair out and you see that fleshy material at the end, a couple of those is all we need. If we don't have enough for the old RFLP system, we go to the polymerase chain reaction. We can type all of the above, plus cigarette butts. Also in interrogation, we're starting to get a lot of cigarette butts from interrogation rooms. Any kind of licked gummy material, stamps, letters, we can also type that. And the general rule for PCR is now, if we can see it, we can type it. So even a very small stain, we can get types from PCR. So on that, John,
All right. And just so that you understand what Dr. Hageman is saying, in the average case, the identification officers or for example, the doctor or nurse at the hospital administering the sexual assault kit and so forth, they're the ones that control the situation. They're the ones that collect. They're presumably trained to collect these samples, bag them, put in the submission form, and send it down to the lab. And of course, your first line of inquiry is to find out how that was done and whether it was done properly. When I say inquiry, I don't mean at a preliminary or a trial, but I mean in terms of your preparation. And the other thing that you must get as part of your disclosure package, you must insist on it, are these case submission forms. They contain a lot of information, and they show the chain of continuity, and there are notations on it which may become important at a later date. It at least gives you an indication of what the police think and the line that they're following, and you get a good idea at an early stage of what's happened in your case. Now, the more difficult situation in terms of collection of samples now arises with respect to general warrants. And in particular, relates to the right of the police to take samples from prisoners. And I'm going to ask Kathy Cooper to address that initially. What are general warrants, and what's the statutory outline, and particularly how does it affect now people in custody?
Okay, well, first of all, just to put this in context, apart from the general warrant provisions in the code, there are a number of different ways that the police can try to obtain samples of bodily substances from accused. First of all, of course, on consent, but that would need to meet the relatively strict Wills standard, and of course that's not necessarily going to be forthcoming from an accused. Samples can also be obtained as an incident to arrest in some circumstances if there are substances on the clothing worn by an accused, and there's some authority that the powers to search incident to arrest extend to hair combings or hair plucking, or even the obtaining of saliva or a finger prick. That comes from one judgment of the General Division here, Mr. Justice McIsaac, in a case called Schweer that's cited, although it's unreported, in the very short paper I did, which is at page C47 in the materials. Now, there's a recent decision from the Supreme Court called Borden that Tim is going to touch on that may very well operate to limit the powers of search incident to arrest to obtain these substances. Also, the traditional search warrant in Section 487 would permit searches of an accused's home or office for items like Dr. Hageman mentioned, tissues, cigarette butts, clothing. But since August of '93, Section 487.01 of the Code has provided for what is termed a general warrant. And it provides for searches in the broadest sense of the word that are not otherwise authorized by law and which otherwise come within its terms. And essentially, they are permit the obtaining of a warrant to use any device or investigative technique or procedure to do anything described in the warrant. So it's potentially of very broad application and can apply to all sorts of investigative techniques. But with respect to the seizure of bodily substances from an accused, and that's just one of the potential applications of that provision, the issue arises as to how far this section goes in authorizing such seizures, and for example, of the plucking of hair or the obtaining of saliva swabs. I can tell you there's a lot of interest on the part of the police in this provision for such purposes, and in fact, some warrants have issued, at least for the plucking of hair samples. Now, none of those have been reviewed judicially that I am aware of yet, but they certainly will be coming before the courts in the near future, and it will be interesting to see how they're treated. Although and what I should say is, although the general provision is very broadly worded, there is in subsection 2 of the section a restriction. Says nothing in subsection 1 shall be construed as to permit interference with the bodily integrity of any person. So on the one hand, you've got a very broad and general power, and on the other hand, it's unqualified preclusion of interference with bodily integrity. And while some of the procedures that I've referred to and Dr. Hageman have referred to are arguably would constitute very slight interference with bodily integrity, it may be that the courts will nevertheless see it as some interference with bodily integrity. Now, it should also be mentioned that some of these samples could be obtained from the accused person themselves with their cooperation, and in such circumstances, perhaps those would not be seen to constitute an interference with bodily integrity. For example, if the accused was asked to spit onto a piece of paper or some material that would produce a saliva sample and cooperated with that, that might not be seen as an interference with bodily integrity, but of course it would require his or her cooperation. And to that end, you should know that in section 487.02, the code provides for the making of assistance orders in conjunction with this warrant or certain other types of judicial authorization, and it may be that an assistance order could be obtained directed at the accused to provide the sample in that means.
Well, that's the Crown side, and that's the problem that we face. But Tim, what do we do to defend? What, for example, if you have an accused who doesn't want to cooperate, or alternatively, you have somebody at a police station faced with one of these general warrants, and the police are demanding blood, hair, saliva, rectal swabs, vaginal swabs, between the toes, whatever, and they don't know what to do, but the police have this warrant. I mean, where do you go? What do you do? What advice do you give, and how do you challenge it? When do you challenge it?
Well, that's a pretty big question.
Yeah.
I think the
That's why you get paid the big bucks.
If I can perhaps answer it in a roundabout fashion, as far as the legislation goes, the $100,000 question is what is meant by bodily integrity. The judgments from the Supreme Court of Canada dealing with admissibility of evidence and blood samples and things like that have preceded this legislation, to my mind, suggest that bodily integrity means any penetration of the body itself, either by a pinprick taking blood or the plucking of hair samples. So Parliament, in passing this legislation, has taken a very, I would describe it as a passive approach to the problem. It would be my interpretation that any warrant that authorized or purported to authorize the taking of blood by way of a pinprick or the pulling of hair would be contrary to both the legislation and perhaps unconstitutional. If you're faced with the situation where the client is calling you from the police station or the jail saying that they've been presented with this warrant and they're asked to present or provide some type of sample, I think the best advice that you can give them is to not consent to the best of their ability and not voluntarily produce saliva samples or present their thumb for the pinprick. It's always a difficult question as to to what extent the suspect can physically resist the police in this situation, but you certainly don't want to counsel them to cooperate and do whatever the police ask them, because not only is the fact of the the cooperation, some indication of consent, but also if the accused has had the benefit of legal advice before he participated in the evidence gathering process, that could well be a significant fact in determining whether it's a knowing involuntary consent or waiver in accordance with the test and will. So I think the most important advice that you can give to a person in this situation is that they not consent under any circumstances to willingly provide bodily fluids, either blood or saliva.
I think as well, you don't tell them to fight or resist, because if they do that, not only might it be an obstruct justice, but it also may be evidence of consciousness of guilt. Tell them as you would with respect to exercising the right to remain silent, that they should say something along the lines of, on the advice of my counsel, I do not consent to the giving of this, and if you take it, you're going to have to take it without my assistance, and just tell them to sit there and let the police do what they have to do. So it's a passive resistance rather than putting up the dukes and fighting it out with the officers or whatever. In any event, having collected whatever the samples are from however they get it, we get to the next part, which is my favorite part, and that is dealing with the reports themselves and preparing for trial. And Dr. Hageman, I think we should turn to some of your reports and let's go through the process of what happens when you get these reports and how you prepare for trial. If you all turn to page C34, right, Dr. Hageman's been nice enough to provide us with a sample of a report that many of you may have seen, some of you may not have. There's a similar kind of report following the sexual assault kit at page C43, but let's deal with the simple one. And this doesn't always apply to homicides. You see a lot of these things in sexual assaults. You may see them in break and enters where somebody's left blood at the scene and so forth. And it all depends on the situation. It all depends on what is trying to be proved by either side. Now, in this particular example, if you just turn the page before, C33, you can see that the officers have submitted a series of samples, B1, 2, 3, 4, and 13, you see. Now, the first question you have is, well, what is B5 to 12? And why weren't they submitted? And you'll often find that samples are taken and not submitted, is that right?
Or not accepted
Or not
by us.
accepted by you, right. And you got to find out what's missing. In other words, put it all together. Now, once it's submitted, you're going to get a report back that varies in the amount of detail. In this one, B1 is presumably taken from the deceased at the time of autopsy and is the control sample for the deceased blood. Is that right?
That's right.
Okay, so now we go to B2, or item 2, which is the blood on Mr. Martin, originating from Mr. Martin, identified on items said to be from Lewis. Now that's another issue, said to be, because it's only hearsay insofar as the report. You have to make sure that they can actually prove that link. But assuming they can, you see it only says B2 sweatshirt and B3 jeans. Grouping results are listed. Okay, now, Dr. Hageman, explain to us the limitations of the report and sort of where we go with this.
Yes, I purposely made this report rather brief, just for explanatory purposes. If you look at the page C35, you will see how conventional grouping systems are reported. And item 3 is a new DNA system. Here I've shown that the genes, I've looked at one stain on the genes. The grouping results in 2 of the systems, PGM and EAP, are consistent with originating from the blood of Martin. And I report it simply as that. Now, what's missing here is, where did I find that stain? How many stains were on those genes? And you'll find that when you get a report, sometimes there are what you would consider holes in it. In this case, I was not asked, perhaps, to do a blood stain pattern interpretation. And I have what I would call a brief version of the report. You may want to know more. For example, where were the stains on those genes?
Yeah, and you see, so many counsel get these reports, and sometimes they come at the last minute, sometimes you get them way ahead of time. But the fact of the matter is that taking the report at face value, is it could be a fatal error on the part, especially on the part of a defense counsel. You must take the report as your starting position and going on from there. And one of the things you do in terms of preparation is you see the number listed up at the top, the telephone number. It's always listed as to how you can get to the scientist who did this. Pick up the phone, call the center, make an appointment, go down, speak to the person who did the tests, right? You're available?
Yes.
And willing to talk?
For you,
Right?
sure.
For me, all right. No, for anybody, really. And when we have that interview, when we meet at your office, what do you have available to you besides the report?
Well, let us know in the phone call what your problems are, what the issues are. For example, you may want to see my original work notes. Well, I'll have those ready for you. Perhaps you want to see this PGM plate. You want to make sure that this was a 2+1+. Perhaps you know about grouping, or you just want to make sure that we've done it right. Well, we have photographs of those on file.
And
So let us know exactly what you want.
And I can tell you from experience that, for example, I want to know where the blood is on the genes. And I'll go down and I'll meet with Dr. Hageman or one of her associates, and I'll make them produce the notes. And sometimes what I then do is ask them for a copy, which I understand you're prepared to do gratis at this point, but not sort of, they won't give you, you can't phone them up and say, can I have a copy of your file? You have to go down and meet with them and sort of separate the wheat from the chaff, but get copies of what you want, because you're thinking about how you're going to deal with this person in cross-examination at the trial. But just as an example, I wanted to know where the blood was on the genes, so I went down and I had a chat, and we looked at the photographs, and it's always marked, you know, X1, X2, and they cut out the little piece and so forth. What was in the notes that wasn't in the report, and it wasn't anywhere else in the Crown brief, was that the blood, when they got it at the center, appeared to be quite old. In other words, that it had been, appeared to have gone through the washer at some point, so that it probably predated the event. And it wasn't noted in the report.
Well, on that one, just for that
No,
example,
but as an example.
I don't think I would have gotten any results from that example.
No, I understand that, but there were, and it was there, and it wasn't in the report, it wasn't you. And it turned out to be quite significant. But you see, I'd never have known that. I would have assumed we're all dealing with fresh blood or whatever, you know. And similarly, if there's something about the report or something about the test and you want to double check and you have your own expert, which is, they're hard to come by, you might want to tell them ahead of time that you're bringing the expert down. And that's the first place you start with your expert, is to have them review what the center did. And chances are they're going to tell you they did a good job, you don't need me anymore, and that's the end of it. Now, the other thing that you'll find, for example, with item 3. Now, tell us about item 3, and why did you do it this way?
It used to be, even 3 or 4 years ago, if we found a very, very small amount of blood, maybe 1 millimeter in diameter, we would have written insufficient for analysis, insufficient for analysis. That doesn't work anymore. We have polymerase chain reaction grouping systems, and we can group it. So for those small amounts of blood, you will not get the table that you see on page C35. You will get the kind of results that you see in item 3. This PCR system is called HLA DQ alpha, or DQA1. It's found in 21 different types in the population. And what I show you here is that the stain on item B4, the hunting knife, is called 1.24. Mr. Martin had the type 1.23. Those are different. That's an exclusion.
Okay. Now, the other thing that's interesting about this report is that Dr. Hageman has also touched on blood spatter interpretation. I get phone calls all the time saying, John, do you know anybody who's an expert in blood spatter interpretation and so forth? And my answer is start with the center, because they're the ones who work in this area. They're the ones who know the most about it. There are some publications around, but start with them first. Go down and have a chat with them. Figure out what they're saying, why they're saying it, and what they've got to back them up, like the photographs or the blood on the genes or whatever. And try and understand it as if you were a juror. Does it make sense? Does it fall together? Take your information, And if you really have some problems with it, and you're not sure that what they're telling you, really jives, then you go on to the expense of getting an expert to second guess it and so forth. Too often I find people start with the independent expert and work backwards, and I think that's a mistake, because you start to get preconceived ideas from the independent saying, what if this and what if that, when in fact you have to deal with the reality. So my advice to you is go to the source. Now, on the blood stain interpretation, you see that it says that the pattern of blood stains beside the head of the deceased is consistent with arterial projection of blood from a source very close to the floor. Now, that's a conclusion, and as you know, you have to know what the basis of the conclusion is. So you go and you see Dr. Hageman and the ident officer, make an appointment to go see the police, go through all the photographs, not just the ones the Crown's relying on, but all the photographs of the scene, and if necessary, try and get those extras to show to the expert, because I found that sometimes they don't give them all the photographs, and there's a little information that they forgot to slip in. And sit down and ask the expert to explain it to you, right?
That's right.
Okay, now, how do you explain this? Like,
In this
just
case,
roughly?
I was given photographs, so I did not attend the scene, but we do attend scenes on occasion. In this case, let's say I did not attend the scene. I look at the photographs, I look at the spatter of blood, and I look at the shape, the size, the dimensions of the blood stains. And with my knowledge of bloodstain pattern interpretation, that is consistent with a projection of blood out from an angle between 10 and 20 degrees
Right.
from the floor.
So that's just in this example. And of course, you'd have the photographs available
Yes.
to you to demonstrate it, and the little telltale signs on the blood and all that sort of thing, right?
That's right.
Okay, now, the most important thing here to remember is this. The chances of you going head-to-head or toe-to-toe, as they say, with Dr. Hageman in the courtroom and you winning are negligible, even when you've got this, unless you've got an expert backed up to say, look, that's all BS, and she's just way out of her league and she doesn't understand anything, which chances are isn't going to happen. So you're going to lose that battle in all probability, but you should explore it, at least in preparation. What you should really be focusing in on, and so many counsel miss this, I don't know why, is that the blood or the saliva or whatever it is that they've analyzed, especially blood patterns and things like that, there's a story being told. It's a circumstantial story, and what you have to do is try and fit this into either understanding the theory of the Crown and whether it supports it or contradicts it, or more importantly, whether you can use their evidence to support your theory of the case. So you have to have a theory of the defense as to what happened that you're going to explain to the jury. And this is a very important area of cross-examination, where once you've established that theory, you then take the forensic evidence and all the prep work and talking to the experts in that, and you plug it into that theory. And we talk about hypotheticals, these long, 10-minute hypotheticals that the jury loses. Wrong, never do that with these experts. Take them through their photographs, take them through the report, take them through the blood on the pants, on the wall, wherever it is. Walk the jury through, step by step, your theory as to the action of what happened at the scene, and use the expert as your foil for doing your little jury address, your mini address to the jury. That's how you use the forensic evidence, and that's the sort of cross-examination you should be geared to. There are those cases that come up where there's a legitimate debate as to the results. Is this really, in the DNA or the whatever the PGM or EAP, did they really do the test right? Is it really scientifically correct? Have they followed the method? Is there a debate going on in the scientific community? I can tell you from experience that those debates, while they do occur, are rare. In the average case, this is to Dr. Hageman, this is just another murder case. This is another dead body on the floor. Here's some more samples for me. I don't know who's right or who's wrong or what happened. And this is what I did, and those are the results. And if I'm not sure, they take a very conservative approach, and it's inconclusive. Now, let's turn to something else. You get your prep, you've done your research, you've made your appointment, you've had your chat, and now you're in court. And Kathy, from the Crown's perspective, because the Crown always goes first with these witnesses, tell us about, well, let's, actually I'm going to switch these around. Let's talk about preserving the record, okay? Let's talk about how we, you know, the problems that you see, because Kathy does mostly appeals and Tim does mostly appeals, and they see our work product from the courtroom, you know, after a trial, it's on the transcript. They have to deal with it. Go ahead, Kathy.
Okay, well, John makes a good point for defense counsel in terms of trying to use the expert to develop the defense theory rather than, and I would urge Crowns, although I don't see too many of them here
I'm
today.
told there are none. Oh, one, there, all right.
To do the, to do the
Good.
same thing to the extent that the strictures of the rules of examination in chief will permit it, rather than simply cataloging the results of the various tests through the expert, try to advance a theory of the Crown and tell your story with that witness and that evidence. Because not only is that going to be useful for the jury, but for appeal counsel and the Court of Appeal reading the transcript. I can tell you that, you know, I always cross my fingers before I turn to the end of the transcript and hope that the addresses of counsel have been included in the transcript, because, you know, frequently when I'm reading through this expert evidence, it really is just a sort of a catalog, and you don't know what the significance of it is, and you don't know what to make of it, and until you get to the end when counsel bring it all together in their address to the jury, well, that may be fine for the jury, but you should know that as a matter of course, the addresses to counsel are not generally included in the transcript, only if they relate to a particular ground of appeal. So appeal counsel in the Court of Appeal may be in the dark to some extent. But it's also, of course, simply good advocacy to attempt to do that as you go along.
Tim, what do you see as problems on the record?
Apart from what Kathy refers to, where the staining isn't properly identified for purposes of reading transcript, one thing to keep in mind that I've seen from time to time is the practice of simply filing the report that's generated by CFS on consent. It's a way of saving time, but to tie into what John said earlier, if you've done your preparation ahead of time and you don't think you can use the CFS expert to advance a theory of the defense or to support your position, and you think a good way of neutralizing that type of evidence may be to go to the Crown and say, well, why don't we, instead of calling the expert, why don't we just file the report? That seems to be done a great deal of the time, and I've had experience to see a case where a trial judge instructed the jury that there was no evidence as to what a rectal swab was, and they shouldn't speculate about what that meant. So it's something to keep in mind. From the other side is if you think that the report can be used to your advantage in explaining the position of the defense, then you should not consent to simply filing the report if the Crown should invite you to do so.
Right. My practice is that unless there's something to be gained, I never, ever agree to the filing of the report. And the reason is that when the jury sees that the report gets filed, they automatically turn off because it's sort of boring scientific evidence. What you have to do is make it come alive, force them to call the witness, and use it in such a way that it's meaningful for the jury, at least from your perspective. The other thing is that there's no authority for filing the report. In fact, the Regina and Pleach and the other one, Regina McShannock, take the position that out-of-court statements, and that's all the report is, are inadmissible for the truth of the content. You can't just simply file them. And a lot of Crowns, after going through the cataloging of all the samples and what the results were, will then turn to the judge and say, I wonder if I could just file the report now as the next exhibit. And you better clear that ahead of time that there's going to be an objection and get it in advance in the absence of the jury, because you don't want to be standing there later saying, no, 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 I object, you know, and then the jury's going to think you're hiding something, so when in fact you're not. So get that out of the way and make them call the witness. Don't let them file the report. Now, the other thing that we should discuss is independent testing. And this is a situation where you have some reason to suspect that that the quality of the work done or the results achieved or the interpretation of the results are challengeable, and you want to have an independent person look at them. Tim, what do you do as a defense counsel to get those samples for independent testing? What problems do you see?
Section 605 of the code authorizes a judge of the General Division to direct the release of exhibits for scientific testing. The notion of exhibit is used very loosely, and essentially any evidence that may be in the possession of the Center of Forensic Sciences or police. You could make an application requesting that that material be delivered to your expert for purposes of testing. The General Division rules deal with this under Rule 21, and there are fairly strict affidavit requirements. You need an affidavit essentially establishing the relevance of the test to the trial, and as well you need an affidavit from the examiner indicating essentially what kind of test is going to be performed. Are they going to preserve the sample, and what sort of measures are taken to ensure continuity and whatnot. From a defense perspective, the one issue that does immediately come to mind is that under it's Rule 21.04 sub 3, in describing the contents of the affidavit from the examiner, it should set out whether the examiner will allow a representative from the prosecution to be present to observe it. And the one concern that you should have is a matter of privilege. And in the affidavit material that is filed, I would certainly take the position that at this stage, when you're simply exploring or trying to gather evidence, that you should make it clear that you're asserting solicitor-client privilege with respect to the results of any test that's undertaken, and that you're not permitting a representative of the prosecution to observe the testing or to take a copy of the results with them.
Do you think we could take a run at the rules, Tim? You know, that they infringe the right to counsel and therefore the right to privilege and all that?
Well, you could say that it's nobody's business what you're doing, but on the other hand, there are legitimate considerations about preserving the sample and matters of continuity and whatnot. So the simple fact that you're taking a test or you propose to do testing and that the sample will be released to an independent agent, I can see your point. You could say that the fact that the prosecution is now alive that you're doing DNA testing, for example, maybe that you're forced to disclose aspects of your defense, but as it presently stands, there's no requirement that you specifically disclose the result, and I would think that as long as you make clear that you're not disclosing the result, and that's a subject matter of privilege, then the rules as they presently stand would survive any attack.
Kathy, what do you say about this independent testing?
Well, I think that there's no principle of general application that sort of resolves that issue. I think the issue of whether or not results are to be disclosed or Crown experts are to be present for testing is a matter that should be hashed out on the application and should be stipulated as terms of the order made. And I think it's important to remember that what we're dealing with here is police seized evidence that have become exhibits of the court, and the applications can be done by either Crown or defense, but in most situations at trial, it will be by defense, no doubt. What you're seeking is release of a court exhibit for the purposes of testing, and I think that there's the court and the Crown have a real interest in terms of what is done with that, particularly where there is only a small amount of the relevant sample that exists, which will not infrequently be the case, and that requires a lot of forethought about the type of testing that ought to be done, whether or not only a limited number of tests can be done, whether that's going to consume the sample, and if so, then surely the Crown and the court have an interest in learning of the results of those tests, or a good argument could be made that the interests of justice require that. In other cases, it may be that that defense could argue that the interests of justice are against the disclosure of the results and that it's not necessary. But I think something should be addressed head-on at the time the application is made, and that it should be expressly provided for in the order. And if the court is of the view that that it's in the interest of justice that results be disclosed and defense is opposed to that, it may be that in certain circumstances you won't get your order. The other point that's worth making, particularly again when you've got a limited amount of sample, as I understand it, some of the testing procedures employed do involve a certain degree of subjectivity in the reading of the visible reading of the results, and that frequently the best reading is obtained while the results are still wet or still fresh. And again, in those circumstances, it might be in the interest of justice that a Crown expert be present at the time the testing is done to also give a valid opinion as to the results.
Dr. Hageman, just dealing with that and also, fresh evidence and so forth, independent testing at the time of trial is one thing. There must be a few people around serving sentence where DNA might exonerate them, for example. Tell us about the problems of preservation and tests and so forth that you currently find, and how can we get around them?
I suppose the issue is we have a 10-year-old sample, we have a 15-year-old sample, if you can find it in the police lockers or wherever these samples are. And if you can find it, do we have enough for RFLP? If we don't have enough for DNA RFLP, do we have enough for PCR? And what we're really developing now at the DNA unit is finding out just how old these samples are before we can or cannot group them. And really what we're doing is we're just expanding the envelope all the time. With RFLP systems, we are looking at cases that are 10 years old, 15 years old. With PCR, I think it's almost limitless. And if you look at the scientific literature, people are looking at mummies and checking the PCR, checking genetics through PCR. So that kind of gives you an indication that it's very powerful.
So the science is there, but I guess the practical question is this: what happens to these samples after you get them from the police? Like, where do they go? How are they preserved? Is there some central lockup, some system of keeping track?
While they're at the center, we have our own system for keeping samples, and it's generally at room temperature. Some of the samples are kept refrigerated. But once we finish a case, we do not keep the items. They are sent back to the police officers. So these items are either sitting in a police locker somewhere, or they're a court exhibit and they're sitting in some storage facility in that way. If the samples are dry, air dried, they are well preserved. If the samples are in any way subjected to moisture and heat, then we start having problems. And that basically, it gives microorganisms the time to start eating up the DNA and cutting it up. And if the DNA is cut up to such a degree that we can't work with it anymore, then we simply don't get a result.
So I wonder how many exhibits are in the bowels of Osgoode Hall and the Court of Appeal or lost somewhere in transit, Tim? We see a lot of that, I guess.
Well, usually when the case gets to appeal, a requisition is sent by the court to the trial office, and they will forward. Under the rules, they're only supposed to forward those exhibits that can be duplicated, which suggests any documentary or documents or photographs can be photocopied. But quite often, you see everything sent, bloodied clothing and whatnot, and it's either in a plastic bag or a paper bag, and with some, I wouldn't say frequency, but from time to time you do have difficulty even finding the exhibits. They get lost in transit or no one's sure exactly where they are. But there is, from the standpoint of appeals, something that can be done, perhaps particularly at this stage of the development of the testing technology. The doctor referred earlier that it's been a slow conversion to DNA-based identification systems, and you may still be dealing with cases now where identification is on an ABO basis or a PGM basis. And it may be a tactical consideration on appeal by way of fresh evidence to attempt to test that material using one of the new systems and hopefully exclude your client as the donor, which the results of such testing would be admissible as fresh evidence on the appeal.
I guess, Kathy, that works both ways for the Crown, but assuming that there's a request from the defense to test something and put in fresh evidence, what position do you take? How do you deal with that?
Well, first of all, if it was a type of testing procedure that was in existence at the time of the trial, I think you're going to have a really hard time overcoming the due diligence hurdle, which is part of the test for admission of fresh evidence. Normally, it's not applied that strictly in criminal cases, but I think in the area of scientific testing, it would be. If it's a new testing technique, that's a bit of a different matter, and I think it's really going to depend on the case. It may be that that access could be obtained to the exhibits for testing purposes, and then you can make your decision as to whether or not you're going to bring an application to adduce fresh evidence, and all of the elements of the test would kick in at that stage.
Mm-hmm. What do you do in a situation like this? Dr. Hageman, maybe you could comment as well. A lot of times, a police officer at the scene will take 20 or 30 blood swabs with controls. They'll show up at the center, and whoever it is that deals with them might suggest that they only need 4 or 5 of the samples to be submitted because the center's so overworked or whatever, or they may, 5 years ago, reject 15 and keep keep 5, and then you go ahead and test. Now, what do you do later when you want to retest and, on an appeal? You want the other 15 or 20. Is it possible? I mean, will you do it?
If there is a reason for doing it, I mean, we realize that when we get a case submission form that we are not getting the whole story. This is an officer's version of what happened, and we go by that. If we get new information that leads us to think that, yes, we have to determine who was bleeding here as opposed to who was bleeding here, if it's informative to you, then that's what we'll do.
Okay. And I guess equally the Crown and the defense, depending on whether they really seek to do justice or not, will waive continuity problems. But I guess those are also problems that you have to deal with.
Well, you do have to be aware of them. You have to determine if that's going to be an issue, and all of this really should be done by way of an application to a judge of the court, have it dealt with under the jurisdiction of the court, whether or not those items are actually court exhibits, or perhaps whether they're still with the CFS, and all of those matters should be provided for and thought through when making that application. while counsel can have access to the exhibits for the purposes of making an appeal book without any court order, if there's any intention of doing any kind of testing, then the only proper way to do it would be by making a formal application to the judge of the court.
Well, hopefully if you do your homework at the trial level, you don't have to worry about that on appeal. Now, we've asked if anybody has any questions. I think Earl made that announcement earlier. We have, I'm told, about 3 minutes left, 2 or 3 minutes to answer questions. Earl or Kathy, are there any questions? Nobody bothered?
I just came into the room and I
Okay. There's a question. Go ahead, Mike, read it out.
I'm sorry, I can't hear.
You said that the Senate Council has to allow the report that they're requesting to be sent to the Crown as part of the agreement.
That's right, when a defense counsel submits items.
You apply the same rules to the Crown?
It's an assumption on our part that there is full disclosure on the Crown's part to defense.
Do you have any policy about disclosure to defense counsel? This was directed to Edwin.
No, from our point of view, those rules are already in place.
I think what Dr. Hageman is saying is this. When the case is under investigation and before the final report has been prepared and submitted to the Crown, the policy at the center is not to provide information to the defense or to anyone else. Is that right?
Unless we have Crown approval to do such.
Right. But once the report has been released, then presumably the Crown is obliged to make full disclosure of that report pursuant to Stinchcombe and the cases that follow it. And now it's an open book, and we have access to you with your consent.
Yes, with reasonable access to both sides.
Right. And the other thing to note is that most people at the Center for Forensic Sciences, in fact, I think all of them, will agree to meet with defense counsel alone. They won't require a meeting to be with the Crown in attendance.
Oh, absolutely not.
I mean, the Crown, if they may want to come as well, and they can't be stopped, but the fact is that unlike some experts who say, well, I'll only talk to you if the Crown is here too, the center doesn't take that approach, and they really have an open door policy. They come under the Solicitor General's office, not the Attorney General's office. Anyone else? Oh, one more?
I can think of no precedent for that yet, no. Because, as I say, I do serology. I haven't done my DNA cases yet. I have not heard of anyone in the DNA unit doing that. No, I'm not saying that it can't be done. But I think it's something that, if you want, I can look into and get back to you on it. But I have never heard of that approach being taken yet.
I wonder, though, that it's a good point, that if you want to keep the results somewhat confidential, you might want to submit samples from 3 known sources, A, B, C, one of whom is the accused, the 2 of whom are not, and not tell the center who's who and have your own continuity problems. I don't know if they have a policy with respect to that. I guess it'll be on an individual case basis. We'll have to see why, and you may have to explain the situation.
We're waiting for guidance on this at the federal level, federal legislation dealing with databasing, what we can do. If we find a match in one case, can we use it in another case? As I say, these things are really developing at the moment, and perhaps with what's happening at the federal level, there may be some kind of light in that area.
So, anyways, we're out of time, and thank you for your attention.
This afternoon is on jury selection. We're a little behind, so I'll be very brief in terms of my introductions. On my right is Gary Clewley, who works in the Crown Attorney's office, as do I. Gary, however, works with the Crown's office in Old City Hall. I'm in North York. To my immediate left is Mr. Ed Greenspan, who I know a lot of you are familiar with. In addition to his reputation as a trial lawyer, he is editor of a number of things that you see every day, those CCCs that you pick up, your Martin's Criminal Code, also participates in a number of educational programs for the Law Society and other groups. On my far left is Mr. Ted Minden, started out in the North York Crown's office and has been in private practice for a number of years, also involved in a number of educational programs. He's someone who is called upon in terms of the Criminal Lawyers Association, but also the Police College, and I know every spring when I go to the Crown's Conference, we usually invite him up as well. So that's the group we have today, and our topic, as I mentioned, is jury selection. I'd like at the outset to thank Shane Kurt of Mr. Greenspan's firm for preparing the paper and your materials. I know when you have an opportunity to look at it, it provides a good general background and also a very good summary of the up-to-date situation with a number of unreported decisions. We're running short of time. We'll ask that the questions, if any, be saved to the end. And the topic we're going to start with, as it is the most controversial one in terms of recent issues, is the issue of challenge for cause. And I'd like to turn it over to Ted Minden to give us an outline of the current state of affairs, particularly in light of the Ontario Court of Appeal decision in Regina versus Parks.
Thanks, Kathy. As Gary Clewley said at one of our recent meetings for this panel, this is probably one of the hottest topics for criminal lawyers. I suppose you're going to hear today that some of us on the panel aren't exactly sure why that's so or how it came to pass that we're in the state that we're in respect of this issue. I've been asked to briefly outline for you what Parks and the companion case, Rollocks, in the Ontario Court of Appeal are all about, and I'm sure we'll all have more to say about these cases a little later. I think the facts of Parks are pretty well known to most of us. Parks, as we know, was a black man charged with second-degree murder for the killing of a white man in Toronto, and there was no allegation or suggestion that race was a factor in that case. And counsel at trial sought to put some questions to prospective jurors by way of challenge for cause. And I might say in passing, as we've discussed at some of our meetings, the second question, which is going to be, I think, the more important one for our purposes, is a question that counsel had been putting or attempting to put in these kinds of cases for quite a long time. I think Ed's going to take credit for being one of the first defense lawyers to ever put such a question, but those of us who practiced in the late 70s and early 80s can probably recall lots of cases when what we now refer to as Parks type questions were proposed. The trial judge, of course, exercised his discretion in Parks and didn't permit the question that related to the ability of the jurors to judge the evidence without bias, prejudice, or partiality, given that the accused was a black Jamaican immigrant and the victim was white. And the trial judge said that the usual presumptions that jurors can be expected to do their duty and so forth had not been negated. There was no evidence called, of course, by way of factual foundation by the defense at the trial, and the counsel simply argued that anti-black racism in Toronto was, quote-unquote, a notorious fact, and that this could assert itself through one or more of the jury members. This all came to the Court of Appeal following Parks's conviction for manslaughter, and the Court of Appeal held that the appellant was improperly denied his statutory right to challenge for cause, which was essential to the appearance of fairness and to the integrity of the trial. They quashed the conviction and ordered a new trial. The Court of Appeal emphasized a number of important principles in the challenge for cause process, one of which was that the right to challenge for cause based on partiality is the only direct means or mechanism that an accused person has to secure an impartial jury, and that the significance of the challenge process to both the appearance of fairness and fairness itself must not be underestimated. The question of whether or not the test in Charette in the Supreme Court of Canada has fallen in a particular case involves the settling of two issues. One, is there a realistic possibility that a potential juror would be biased by reason, in this case, of his color? And secondly, is there a realistic possibility that a prospective juror would be influenced in the performance of his or her judicial duties because of the racial bias? What makes Parks, in my view, a watershed case is that for the first time, there is legal recognition in the Court of Appeal for Ontario to the realistic possibility of race-induced partiality in general. And as you know, if you've read it, Mr. Justice Doherty refers to some of the studies and the research done in the area, and he accepts some of the broad conclusions based in some of those materials, namely that widespread anti-black racism exists in Canada, and in particular in metropolitan Toronto, and that there existed a realistic possibility that one or more potential jurors would be consciously or subconsciously affected by all of this and come to court with stereotypical attitudes toward black persons that could affect their ability to be impartial solely because of the color of the accused. In fact, Mr. Justice Doherty said there can be no doubt that that was the case. So I suppose one question is, well, is Parks confined to anti-black racism in Toronto cases? We don't know, of course, with any precision what the limits of Parks might be, but Mr. Justice Doherty finds that the social science research, and this is a quote, goes at least so far as to indicate that there is a realistic possibility that jurors' verdicts are affected by the race of the accused, where that accused is of a different race than the juror. So that language, I would suggest, seems to indicate that Parks will not be limited to cases involving black accused or of a black accused facing allegations of interracial violence. Finally, Mr. Justice Doherty in Parks specifically rejects, and this I think is very interesting, rejects the use of a cost-benefit analysis. He's not going to get into discussions about, well, how much longer trials are going to take because of this kind of approach. Fairness cannot ultimately be measured on a balance sheet, says Mr. Justice Doherty. So the importance of Parks, I think, is that the whole notion of the importance of the accused actively participating in the selection of an impartial jury through this process is now right on the table as a result of Parks. And I think it's fair to say that it's on the table in a new way, and perhaps, if it had stopped right there, in an enlightened way. And the key then becomes, what does that mean about other forms of bias? What does that mean about other forms of bias apart from racist views that can lead to a lack of impartiality? Can those kinds of biases be set aside? Well, the next development was the case of Ricky Rollocks, R-O-L-L-O-C-K-S. Rollocks is also a decision of the Ontario Court of Appeal, and it was also authored on behalf of the court by Mr. Justice Doherty. It was heard June 16, 1994. Very quickly, the history was that the appellant in that case was black and was convicted at trial of 2 counts of sexual assault. His trial took place in Toronto about 2 years before Parks was decided. Rollocks at his trial did not seek to challenge for cause based on racial prejudice or on any other ground, and there was no concern raised at his trial about racial prejudice at all. So the issue became, is any black accused who was convicted by a jury in Toronto and whose conviction is still in the criminal justice system when Parks was decided, entitled to a new trial so that he can challenge for cause based on race-induced partiality? This led to Mr. Justice Doherty, and I think you should read Rollocks to get all the details of this, but Mr. Justice Doherty then looked at the question of whether or not Parks was, quote, new law, unquote. And it arose in the very narrow context of whether or not an issue raised at trial can be raised on appeal. Generally, of course, we know there's a prohibition against that. In Rollocks, it was argued by the appellant that as the law stood at the time of the trial, he couldn't challenge for cause based on non-specific allegations of racial prejudice, but that Parks changed the law regarding challenges for cause in the province, and that since the convictions were under appeal when Parks was released, he's entitled to rely on the new law created in Parks. The Court of Appeal held that only where there is a fundamental restatement of the law, which overrules established authority and sends the law in a new direction, can there be an exception to the general principle that new issues cannot be raised on appeal. And Mr. Justice Doherty framed the issue in this way: has there been a dramatic change in the existing law so that it can be said that established law has been reversed and created a basis upon which challenge for cause could be made that did not exist prior to Parks? And he cites it as an example in terms of what would be a dramatic change in the law, the case of Ancio, that fundamentally changed the basis of an attempt murder. Mr. Justice Doherty goes on, and I'll try to hasten this along a bit, that virtually everything in Parks came from principles established in Hubbard, Sherratt, Zundel, that the opportunity to challenge for cause on the basis of anti-black prejudice was always there. It was there when Rollocks was tried. Because trial judges were not disposed to exercise their discretion in favor of permitting such challenges, does not detract from the right to bring that application. So he concludes that Parks is really consistent with pre-existing binding authority, that it developed the law, that it changed significantly the practice and procedure in our courts, but it didn't change the law. There's nothing new about it. I think that Rollocks can be interpreted by some to limit Parks to cases that are right on point, anti-black racism in metropolitan Toronto. I don't think that's the accurate interpretation of Rollocks, but I'm quite convinced that it's subject to that interpretation, and that there will be lots of people in our profession, crowns and perhaps judges, who will seek to confine Parks on the basis that it really doesn't change anything. I'm not sure why Mr. Justice Doherty chose to use the language that he did, but perhaps that's something we can all talk about.
Gary, are there any alternative views?
No.
Ted, could you briefly cover what may have to be called as far as evidence is concerned if you wish to raise an issue?
Well, I'm not sure I know the answer to that after reading all of the cases. because in Parks, according to the Court of Appeal, we know it's a notorious fact that there's anti-black racism in Toronto. I suppose if you could come to court confident that the trial judge was going to recognize as a notorious fact that there was anti-Southeast Asian prejudice in metropolitan Toronto, then you wouldn't have to file any material. But I'm not at all confident that that will be the case, and I am of the view that the safe course would be to do the legwork and to get material which is readily available by way of affidavit from experts in the field of social anthropology and so forth, as a factual foundation for whatever it is you're alleging.
I'd like to turn it over to Ed, please. Are there other areas other than racism where you would consider raising other types of issues under challenge for cause, and what basis would you put before the judge for doing that?
Well, I think that, first of all, I must remember that in Parks, there is no suggestion in that drug-related homicide that there was any racial component to the crime. And so there are general statements that are made in Parks, I think, that would lead to the rule in Parks, whatever that rule happens to be, to me more broadly applied in areas like sexual assault cases, as to whether or not people who themselves have been victims of sexual assault or have family members that have been victims of sexual assault or have friends that have been victims of sexual assault, whether or not that would make them unable to fairly try the case. Credibility of police officers, violence against women generally. Madam Judge Pat German decided a case where she allowed a challenge for cause in a case called Kitachik, which is in the paper, where she decided that because it was a crime, it was a sexual assault, where it was a murder, man on a woman, that because there would be generally, and it's notoriously known that there's violence against women, and people have certain views about that. Even a number of them have a certain view that we shouldn't have a presumption of innocence when the victim is a woman and the accused is a man, and she says that without any evidence being presented before her. She says, I don't want those people who harbor those feelings on a jury, so I'm going to allow you to ask that question. And then rejects on an earlier point several other questions that are put about whether you have empathy to victims, because there's no evidence before me that by merely having empathy to victims that you can't fairly try the case, so I need evidence of that. Parks, I think, has set a tone for, and I think Rolex has possibly confused it a bit as to what you can do and what you can't do. I think that in Parks, what Mr. Justice Doherty is saying, and then tries to limit himself in Rolex, is to say that whatever the area is that you want to get into, that there has to exist a realistic potential for the existence of partiality, which is what comes out of the Supreme Court of Canada and Sheriff, and there has to be an air of reality to what you're suggesting, and that there has to be some minimal requirement of information being imparted to a trial judge. Because even though he limits himself in that case and then tries to retreat in Rolex and say, because what he says in Rolex is clear, it's now essentially judicial notice, that it's a matter of judicial notice that in metropolitan Toronto, there's at present day, there is an anti-black racist feeling that permits you to ask these questions. That's what he says. But he relies on material that go beyond that, to talk about racism in Canada. And I think you file that material, you can get it for all kinds of other colors, of other kinds of people, and you can go into areas of sexual assault, credibility of police, violence against women. There's no end to what the imagination can now bring to bear on the ultimate limits, which I think are very few.
Gary, I'd like to know if you have any response to that, and following that, are there any times that the Crown wants to challenge for cause?
Well, I was being a tad facetious when I said that there are no alternate views. Obviously, these arguments don't fly on the West Coast, because in the case of Williams, which involved a native guy who went in apparently and robbed a store with a BB gun, in which there was no allegation that the crime was racially motivated, the Chief Justice of the BC Supreme Court said that he wasn't impressed with the argument that the jury ought to be canvassed about the possible prejudice against Native persons, notwithstanding that, among other materials, the defense called a judge who had recently conducted an inquiry into racism against Native people out in the area, arguably more scientific than a letter from Stephen Lewis. But the effect of it all was the judgment of Williams, which is set forth in Shane's paper, is a rhetorical question to Mr. Justice Doherty, and that's, as I read it, why the leap in logic? Assuming that there's prejudice in the community, why do you assume that the present safeguards are insufficient to forestall that prejudice from having any impact on the manner in which the jury or jurors conduct themselves? That question is answered, it seems to me, in Parks in the affirmative. It might, therefore it will, therefore the challenge for cause is necessary. British Columbia Chief Justice says, I don't believe it, and I'm not going to follow it. So obviously, while I agree with what has been said as to the effect of Parks, it obviously remains to be seen whether it's a new era or just some Caribbean vacation for the defense bar to ask a whole bunch of questions that were otherwise and heretofore not permitted. Obviously, if the gates open, and the way I see Rolex, it's the Court of Appeal standing at the barn door wondering where the horse went. If it's good for the goose, then the gander's going to get on board, and obviously the Crown is going to want to know whether these folks belong to groups, you know, the West Indian Defense Fund, to find out if they have any prejudices, which are going to result in an unfair trial, but favorable to the accused, and not based on the evidence.
I would think telling a bunch of Ontario lawyers that this is not the law in British Columbia is not all that helpful, because it happens to be the Court of Appeal of Ontario that speaks once, twice, three times, and this is where most of us tend to live, and not in the Caribbean. And so we have to take what Justice Doherty says on face value and extend it. And the fact is that a number of general division judges are prepared to extend it without a lot of material. They're prepared to extend it on newspaper stories and nothing more. They're prepared to extend it in areas of sexual assault, and there's no question that the rule in Parks, I think, tells us that even though Mr. Justice Doherty is looking at material like Stephen Lewis's report, which may have been submitted by letter, I don't know, but his report that is submitted is an anecdotal report. There is no question about it. You can't identify in such a manner that there's a scientific analysis of it. And therefore, anecdotal information will be good enough. For instance, in one of the cases where there was let me just find it for a second, the case of Pasco, which is in your material. Shane was able to dig out an anecdote about it by Mr. Justice McIsaac, which was a homosexual pedophile, sexual assault, and 2 charges. And he did allow certain questions based on the fact that this is a charge that would inflame a jury, but he did not allow this question. Have you or any of your close friends or relatives been the victim of sexual assault? such that it would prevent you from giving Mr. Pascoe a fair trial based only on the evidence given at trial. Some judges, as a result of Parks, say that's an okay question. Some are saying that's not an okay question. And the anecdote that Shane finds out from counsel is that the following day, a juror came forward, said, I've got a migraine headache, I can't handle this. This is reminding me of when I was younger, the sexual assault that occurred on me. I can't deal with this, kick me off this jury. Now that's not a bad anecdote. It's as good as Stephen Lewis's anecdotes in terms of his report. And if that's what the court is saying, that anecdotes are enough, what I wanted to suggest today is that I think defense counsel, for every defense counsel in every case, will have an anecdote. And an anecdote should go to the Criminal Lawyers Association. We should build up a fund of these anecdotes. And then, and I'm not kidding, okay? Because they're as good as Stephen Lewis's stuff, which Doherty says is good enough. And I think that you could probably, that the floodgates are open, the barn door is open, and Gary should probably move to British Columbia, where he and his uncle, Mr. Justice Essen, will have a good time. Because that case is nonsense. That case is truly nonsense. To suggest that he can distinguish it from Parks in the face of that overwhelming evidence about racism against natives in British Columbia, that case is a joke.
I'd like to move from what issues can be raised to the issue of how questions are asked. I'm going to pose a question and ask for some response from the panelists. In a case of welfare fraud involving a recent immigrant, if the suggested question was as follows: do you belong to any organization that is against Canada's immigration policy? And if the answer is yes, will this affect your ability to assess the evidence without bias, prejudice, or partiality? Starting with Ted, do you think that question would be appropriate?
Well, I think we have to distinguish between what's an appropriate question in terms of what the court might accept, ultimately the Court of Appeal, and what's a tactically good question. I'm not sure about this one really on either score. I suppose if our view of Parks is correct, then it's a legally permissible question, and with sufficient factual foundation, which I suppose if we can rely on anecdotes, we can probably get to ask the question. But whether it's a question, the answer to which is going to be at all helpful, I'm not sure.
What about the personal inquiry aspect of it?
Well, to me, all of this is personal. I mean, to ask somebody if you can set aside any prejudice that you might have about people because of the color of their skin, what's not personal about that? So I have a little bit of difficulty in that kind of distinction that the Court of Appeal seems to seize on.
Any response, Gary?
Well, I mean, the question really asks, do you belong to the Reform Party? And if you do, does it make it impossible for you to give this guy from the Philippines or wherever a fair trial? I mean, you know, if they want to know if he belongs to the Reform Party, ask him out on the street. It seems to me the question is not whether people come to court with biases or prejudices about immigration or any other thing, the nature of the offense. Nobody's in favor of murder, for example. So, at least that we've heard about recently, and although there'll be anecdotes. So I suppose the question on the table is there enough evidence out there that, notwithstanding that folks come to court with some biases, prejudices, and whatever else you want? I'm not talking about racists. Can they put them aside and give the person a fair trial? So I think the answer is no, it probably shouldn't be allowed, but on the basis of what I've been reading, sky's the limit, so sure.
This would be, I guess, addressed both to Ed and Ted. Using this challenge for cause, do you think your clients will get a fairer trial?
All right. Well, I think probably the most important part of this to me is the perception of the client, which I don't think can be emphasized enough. I think that's very, very important. I think the Court of Appeal makes it clear that they consider it to be important, and I think it does go a long way to improving the perception of our clients that they're getting a more impartial jury because of the process. But how effective is it really at weeding out people? I'm not yet prepared to jump on the bandwagon that it's the greatest thing. I think it's an interesting process. I think you can learn a lot through the challenge for cause process about the people that are coming forward. But whether or not the answers we're getting to these questions are honest answers, I think there's a lot of debate about that. I have a lot of doubts about it. I think the best story, speaking of anecdotes, the best story I've heard from a lawyer I know was a case where the challenge for cause went ahead and everything was going along fine until the proposed juror answered the questions in the right way, quote unquote, and the jurors deliberated and bumped the person. And the trial judge assumed that, or guessed that they had misunderstood some of the words like impartial or not indifferent, or had misunderstood some of the instructions, and so tried again. And the triers huddled and gave the same result. They bumped the juror. No one could understand this. The next prospective juror came up, and exactly the same thing happened. This really happened in a case in Toronto, I'm told. 2 times in a row, and everybody in the room was exasperated. Everyone assumed that they weren't understanding what was going on. The rest of the procedure went fine and as expected. And the courtroom was sort of buzzing as to what could have gone on. Did it finally sink into them what they were supposed to be doing? Word filtered back from one of the deputies, you know, those people that aren't supposed to say anything but always do. Word filtered back to the lawyers involved that the triers knew exactly what they were doing because the 2 people that they had bumped had said some things in the jurors' lounge that were quite clearly racist, and they'd overheard it, and it was a black accused. So that story has stayed with me ever since I've heard it, and it makes me really wonder whether we have any idea what's really going on in that process.
Actually, I'm going to change the question slightly when I turn it over to Ed. I was watching this take place in a case I was doing on sexual assault where the question was quite long and involved, and once again, often the appropriate answer was given, but if there was any thoughtfulness or hesitation by the juror, then they were, as Ted was saying, bumped by the triers. And I'm wondering, Ed, do you really want to turn your jury selection over to such an extent to these 2 people in the jury panel?
Well, given that I'm skeptical about this entire discussion, that the jury selection is not a science, I laugh at almost everything I read about people sincerely giving their views as to whether women should sit on the O.J. trial or not sit on the O.J. trial, or black should sit or white should sit. Nobody knows what the hell they're talking about. Nobody knows what the hell is going to comprise a good jury. And if 2 jurors want to remove somebody because they hesitated before they gave an answer, because I think the hesitation may be because they don't want to admit they're racist, I don't believe people will admit that at all. You're not going to cross-examine someone unless you're going to have questionnaires and wide open questioning, as long as you're going to play the silly game in Canada of the 2 tensions of judicial control and how far can we go. Unless you're going to go the whole way, you're never going to get an answer out of somebody, you know, are you a racist? Nobody thinks they're bad people. People think that they're pretty decent. Even, you know, Attila the Hun went to bed every night thinking he was a good human being. People aren't going to admit they're racist. Very rarely are people going to say that they're racist. So if you're going to hesitate in giving an answer and they're going to be removed for that reason, it's no less arbitrary or no more arbitrary than if I just eyeballed them at the beginning of the trial and liked them or didn't like them. There's just no science in this at all. So the short answer is I don't care. And I mean it, to take this stuff too seriously, to truly get into this nonsense of, I mean, all you have to do is read, and I brought all kinds of stuff that are just, it's a joke, between Jerry Spence and Roy Black and this argument as to who should sit on juries, that men shouldn't sit on this, women shouldn't sit on this, you know, it's crazy. It's craziness to suggest that there's any science in this at all. And this is 90% a waste of our time. But I can understand the process. The process is solely not to get a fair jury or one that's going to favor your side. What you're trying to eliminate, if you can, is the absolute borderline wackos. You're trying to get that extreme bunch off that jury, the most offensive bunch that you can possibly locate. That's what you're trying to do. And so if they eliminate somebody who hesitates in an answer, so what? There's another 200 of them.
I want to take the advantage of the wealth of experience sitting beside me. We'll probably be able to give them about 3 minutes each. How do you pick your juries? Ed?
Want me to start?
Yeah.
I once read an article by a lawyer who, the thesis is that you should not pick left-handed jurors. And it was seriously offered as a thesis, and I wondered, how do you find that out? Do you throw a ball to them? So we all go to law school, we all get our degrees, we all go to O'Keefe Center, wherever you go now to get your law degree, and you become a lawyer, and then we're all experts. We're all experts. We all know who to pick on what juror. We know that if you're from Central Europe, then you respect authority too much, and you don't want them on a jury where the police evidence, everybody's got their own opinion. And I remember in my second trial, the second jury trial that I ever had was a rape case, and I ended up, and the rule was no women on rape cases. And I had 8 women on my rape case. So when I went into the coffee lounge at 361 University, lawyers wouldn't talk to me because they knew in about another year I'd be going back to Niagara Falls since I was a pretty lousy lawyer. I picked 8 women on a jury. Then I got an acquittal. So I would walk around saying, got to have women on a jury. Got to. I mean, on a rape case. They must. Okay? That's the rule. The fact of the matter is I haven't got a clue. Okay? And I don't think anybody in their right mind has a clue, including the experts that you pay the $1,000 a day to come and tell you. To come and tell you that in a case involving abortion, you should ask a potential juror, are you Miss, Mrs., or Ms.? They're going to pay $2,000 to know to ask that? Common sense tells you who you don't want on a jury. That if you're involved in a case of a robbery of a Max Milk store, you probably don't want somebody that works in a Max Milk store. Or even a Becker's. You don't need them to pay you $2,000 to know that. It is common sense that will tell you what you have to exclude. The rest is utter bullshit, okay? Make no mistake about it. Read every article you can. I mean, I brought all these articles about female prosecutors in New York thinking that women should sit on cases involving sexual assault or preppy murders. And now she says, wait a minute, I think women more than men tend to base their verdict on external appearances, and if the accused is an attractive man, they'll acquit him. So now I don't pick women. She's as nuts as the other side, okay, that says you should only have women. There is nobody that has any notion. It sounds right, everybody's got their view, but as far as I'm concerned, I'm on a trial right now in a general court-martial where I got my jury. The first time I saw my jury was when we walked into court. I had no choice, no chance, no nothing. I walk in, they look pretty good. I'm in the middle of it right now, so I want somebody, but they look fair. And David Humphrey, Mr. Justice David Humphrey said he was never convinced that you shouldn't just take the first 12, that at the end of the day, he didn't know whether or not he got any better or worse justice than if you take the first 12. And I think there's an awful lot to be said for it.
Now that Ed has said that no one has a clue, Ed, do you have anything to add?
I certainly don't have a clue. Just picking up on what Ed has said, Mr. Justice Humphrey used to have a fair bit of success taking the first 12. I was fortunate enough to article with him, and I saw him do it. He'd stand up and say, "My lord, the defense is content with the first 12." And like I say, he seemed to do all right. I know Mr. Maloney used to do that a lot as well. The only comment that I pulled out, I've got the same New York Times article that Ed brought along. The only comment that I pulled out from Jerry Spence that I think I agreed with was this, when he was asked, Ed, you might not agree with this, but I'm going to read it anyway. He says, "I don't care whether jurors are rich or poor, black or white, male or female, old or young, or what they do. I want to know if it's someone I can bare my soul to, someone who will listen to me, someone I can be a friend to, or if it's some cynic or jerk who's full of hate." Now, how he knows whether the person is a cynic or jerk or who's full of hate, I agree with Ed. I don't think he knows. I know I don't know. I think you just listen to your gut.
I just want to add one line to that. Jerry Spence has got a much better chance in the States of learning that than we'll ever know in Canada. Because even with all of these cases, Parks and Rolex or whatever it's called, whatever, with all of these cases, the fact is that you have a limited ability to question. You'll always have a limited ability to question. The question is just so, are you able to fairly try despite the fact that, you can't go beyond that. So it's all a joke.
In O.J. Simpson, there was a 300-question questionnaire. That's before the lawyers and the trial judge got to them. And it included questions like, do you watch Monday Night Football?
Gary, any comments on picking a jury?
Well, it's just that notwithstanding that I agree that it's a crapshoot, it's still one of the best parts of the job. You get to indulge in all of these things that are now prohibited. You're told that you sit there while the trial judge tells the panel that the Crown and the defense are going to exercise this thing called a peremptory challenge, which is going to be based on their biases, prejudices, and other unreasonable factors, including just how you stand there, but don't be offended. And that's exactly what you do. And it may be imperfect, but it's a hell of a lot of fun, and we do it anyway, and we plan to continue to do so unless they take them away.
I'd like to thank members of the panel. I'd like to thank you for hanging around 15 extra minutes. Hope to see you in 2 weeks' time.